Hey, welcome for everyone who's joined us so far. My name's Cal Davidson. I look after partnerships at Cake.
I'm Charlie. I'm COO at Cake. I was a lawyer in my previous life, but I would be very rusty now, so I'll be leaving all the complicated stuff to Helen to run through. But today I'll be providing my perspective on bear trusts and what we see at Cake, from the really early stage experiences to the Series A B plus, and providing some perspectives on some of the challenges, pros and cons. I'll let Helen introduce herself.
Hi, thanks, Charlie. So I'm Helen, practice leader at Legal Vision. I head the tax and corporate team at Legal Vision. I do a lot of work with startups, particularly around structuring and working on different strategies for exits and growth. I do a lot of work with the capital raising team, particularly around how to structure investments coming in, and really about the bear trust arrangements that we're talking about today. Like Charlie said, this webinar is really to talk about the basics of bear trust, how you can use them, the compliances, and I guess some misunderstandings of how these structures can be used. On my end, I'll really be kind of talking about the legals, some of the legal considerations, the tax considerations, and how to even set up a bear trust in the first place, and kind of things that we see from a capital raising side, as in tips and discussion points. So thanks, Charlie.
Amazing. Thanks, Helen. So in terms of what we're looking to cover off, obviously we'll start with what is a bear trust. There's a few misconceptions out there. So we'll make sure we get into what it actually is. We will compare the difference between a bear trust and an employee share trust. They are often misunderstood as being the same thing. Confusion on the bear trusts and when to use them. There's a few different applications, and Helen and I will both provide perspectives on when we see them most effectively applied. Tax and legal considerations. Very much that will be Helen explaining through that and me asking a few stupid questions, I'm sure. What's involved in the setup? There is a bit involved there, the ongoing management, and then also the management of the beneficial holders behind the bear trust, which is a really essential component of successfully setting it up, but also administering it going forward. And then, of course, plenty of time for questions at the end if you do want to wait until that point. But yeah, as I mentioned, don't hesitate to post in the Q&A chat, and Cal will be keeping an eye on it, and we'll yell out as we go through. Great. I'll let Helen lead with what is a bear trust.
Thanks, Charlie. So what is a bear trust? Like, what does that mean? A lot of you may have heard of a bear trust in a different kind of context, more so probably in the property or maybe even a super fund kind of context. But a bear trust essentially is just a trust where a trustee holds an asset on legal title for the benefits of the underlying beneficiaries. That particular trustee has no interest in the assets and doesn't have control over those assets unless those directions and controls are coming from the beneficiaries, which is why it's called a bear trust, because that trustee doesn't actually own those assets. It's merely just holding the title. And as you'll see as we go into this presentation, it's talking about why you would even have that and what the benefits of having this type of structure could be. Today we really are just focusing on how a bear trust is used for investors and how a startup can use it to its advantage. And as Charlie mentioned, we'll touch on employee share trust and how that's different, because there are misunderstandings as to what is the difference, are they the same thing? And we do actually get a lot of clients who use a bear trust when really it should have been an employee share trust and vice versa.
Amazing. So let's jump right into the key differences then, because that is something that's been asked a lot at Cake more recently in terms of when customers of ours are looking to set up for the different purposes.
Yeah, I mean, we do actually get so many clients that come to us that have already actually received advice that they should have a bear trust when they're actually entering into setting up an employee share scheme, and the scheme itself should actually be tying with an employee share trust as opposed to a bear trust. And the key difference is that an employee share trust is dictated under certain tax legislation. There are certain rules as to the purpose of that trust and the control over the trustee. The control is coming from the company or the directions are coming from the company itself as opposed to the underlying beneficiaries. So there are slight differences as opposed to having a bare trust where that control and direction is coming from the beneficiaries, which in a case of employee share trust are the employees. There are also certain requirements under tax law which requires that trust to be only for the sole purpose of holding shares for these employees, and the various kind of activities underlying that trustee to be for that sole purpose. And if they don't kind of meet those rules, then the status of that trust then falls outside of the definition of an employee share trust for tax purposes, and it means that status is gone forever. So it does have, quite, I guess there are tax implications in meeting an employee share trust, and why a bare trust doesn't kind of just fall into these kind of rules when you have employees. And that's why I think it's really important to get advice at the beginning to understand what are we actually doing here. Are we trying to set up a structure to hold shares for employees, or we're actually trying to set up a scheme or a structure to hold shares for investors? They're very different things. And as you can see on the slide, a bare trust is generally used for investors that are not employees, whereas an employee share trust is used for employees under like an incentive scheme for employees.
It's super interesting because I think often the startup mindset is do what's quicker and easier a lot of the time. And when founders or early stage employees are looking at this structure, the bare trust does just look easier, and they think we'll use that one. But like a lot of things with startups and especially options, it's tax driven. So if you set the wrong structure up from the get-go, not only will you potentially have to fix it later, but you might impact the tax benefits that the employees could get from those incentives too.
Yeah, definitely. We've actually just we've the last week we've done 4 employee share trusts, and it's pretty crazy. It's like this everyone's just realizing that this type of structure exists, and 2 of them came to us with the exact same issue, is saying we need a bare trust because it's really simple and we just want to put all of our minor employees into this bare trust, not realizing of the tax implications and the differences.
Makes sense. Cool. So in terms of what is not a bare trust, we do get this confusion a lot. The first basic one is the difference between bare trusts and family or discretionary trusts. The confusion there most often comes on the investor side rather than the company side, but it is something that the companies often have to deal with, especially when they're communicating with investors about setting one up. You might have investors come back and say, no, we've already got a trust set up. It's this name and it's this. Or if they're entering into any documentation, some of them will mistakenly say, my shares sit in the bare trust because they've heard bare trust, but they're actually referring to the fact that they have a family trustee that holds the shares, and completely different structure for a very different purpose. That's all for the investors' tax management rather than for the company administration and governance and whatnot on the company side. Other one is the unit trust, which I believe is more similar to the employee share trust, which Helen can go into, but it's a broad topic, the unit trust, but that is a different structure with completely different discretion on the trustee side, but that is often confused for a bare trust too. SPVs, for any companies that have joined that are dealing with US investors, or perhaps even that have or are considering flipping up to the US. Sometimes a special purpose vehicle, an SPV, is confused for those companies especially. It is a different structure again. An SPV isn't simply the US version or the syndicate version of a bare trust. It has different obligations, different tax, and a different setup. And then we don't see this as often, and this is probably a good thing that the startup ecosystem is getting great help through it, but sometimes we do come across structures where they're labeled as bare trust, but they've been set up in a very hacky fashion. And whether or not on a tax view or corporate view, they'd be considered to be a proper sound bare trust is arguable. So hopefully this webinar and Helen's advice will be useful around how to set them up properly, because there's no point half doing it really, because you might just have a big mess to clean up later. And the time when that comes up, as much as I would advocate for moving fast and focusing on the company momentum, often the time when structural things like something not set up properly will come up will be when you're raising capital or you're at an acquisition or an exit, and it can cause a lot of problems at that point.
Yeah, that's a really good point, Charlie, especially where people think they've set up a bare trust and they've called it a bare trust, but actually the terms of the document may actually be terms of a discretionary trust or a unit trust, for example. And actually understanding, what is a bare trust in the first place and how these are different. This is different to, all the various trusts that you've just set out. And we actually see this a lot as well, where at those exact points, where you're doing a raise or there's an exit or business sale, the due diligence that arises, all these documents come out. So getting that advice right at the beginning and understanding, the structure and actually putting the right documents in place is so important. You just don't want to deal with that mess later on.
Absolutely. It can be embarrassing at the least, or it can kill a deal as well at worst.
Yeah.
Or even potentially just change the value of the deal because of the costs involved and delay involved in cleaning that up. So always good to have a clean house going into that
Yeah.
sort of situation.
Yeah, no,
But you take-
definitely. So the next slide here is why would you even use a bare trust? Where we generally see people using a bare trust is the top two reasons actually. So the first one is where you've got a number of minor investors coming in holding very small percentages. You may not want to have all of these odds sitting on your cap table. One, it doesn't look very attractive. When other bigger investors are coming in and they just see so many investors on the cap table. The second reason actually what ties into the administration side is if you've got so many minor shareholders having to give notices or collect signatures can be quite onerous. So trying to reduce that administration side when you have a lot of minor investors is quite key and can flow into cash flow time, speed of doing things at a startup level. The second point is the shareholder limit. So some of you may already know that if you hit the 50 shareholder limit in a company, in a private company, it can tip you over into being a public company. So when you're at that stage where you're at the 40, kind of 30 or 40 mark and you're about to do another round, another capital raise round, you may want to think about, okay, how can we ensure that we're not, moving into that 50 shareholder limit or even in the takeover rules, how can we ensure that doesn't happen? Because you then have to deal with, other compliance, regulatory, considerations, and it can be very onerous. And so that's when you think about using a bare trust, because a bare trust, everyone is sitting under that one trust. As I mentioned before, the trustee is holding the shares on bare trust for the underlying beneficiaries. So you may have 10 investors coming in. Instead of having 10 investors sitting on the cap table, you just have that one trustee holding all of those shares on behalf of those 10 shareholders, meaning your cap table is sitting at less. You're not as close to the 50 as you normally would be.
Yeah, I think when we think about that, Helen, it often sounds like the perfect solution. And that's where I think startups will often jump at it and go, this is the perfect fix. But yeah, as we'll get into, there are a few steps obviously to consider when then deciding to go that route as well.
Yeah, I mean, actually going off that, Charlie, and on that third point, the administration, and I did mention, it does reduce administration at the top level of the company, but something just to keep in mind is that just because you've reduced the administration on the top level where you're not collecting signatures or issuing notices to all your minor investors, as you'll see later on, when you're setting up your company, you need to have a trustee. That trustee would basically take on that administration. And it's still something to keep in mind that it doesn't just go away. It just moves it from one entity to another. It does obviously reduce administration from a ASIC perspective, lodging ASIC notices and updating your register. And it does speed things along because then you're not having to deal with the underlying beneficiaries at the company level. You're just dealing at the trust level, which does help. That kind of moves into the fourth point is the mitigating the non-compliance. So this is more about when you need to update ASIC, and if you're not having to update ASIC with the 10 shareholders, it just saves you that time and also any late lodgements because you're only dealing with the one trustee entity that has to sign all the documents, updating ASIC, with those changes. So those are kind of the the compliance regulations or administration that gets mitigated when setting up a bare trust. The last point there is just about privacy. So this is actually something we see not just for startups and investors coming in, but also just shareholders or founders that want to, for certain reasons, they might not want to have their name on the public register, and where people can actually see the underlying owner of, those shares. So setting up a bare trust may be another option for people in those situations.
Just a related question here in the Q&A was about do you need to disclose the actual beneficial holders to other investors when, if you're actually sharing your cap table as part of a raise process, something like that? There was a question about that.
Charlie, do you want to take that one? I'm happy to
Yeah,
also
sure.
jump in on that. Yeah.
Yeah, I think it depends. I think it depends on the investor coming in. If they're a VC and they've got strict DD that they require, it probably is a likely question. They won't just say, okay, you've got a bare trustee, no worries. They will say, how many beneficiaries, who are they? A reason for that is on their side, they need to de-risk as well. Because while the bare trust, as Helen said, does mitigate some of the administration and approvals and whatnot, the VC wants to know who they're, getting into bed with, for sake of a better phrase, and make sure that any beneficiaries there, firstly, won't create any problems for them, and secondly, probably check for conflicts as well.
Yeah, no, definitely. I was actually speaking to our capital raising lawyer about this point earlier, about a different matter, where this is that question. And I agree with everything Charlie said. It depends, it's a case by case. And if that's why it's important that even though you have this bare trust, you have all your ducks in order, you have all the documents there, and your investors can ask for that information to be given to them as well. Because like you said, your investors coming in want to know who they're getting into bed with and who they're doing business with.
Right.
Exactly, yeah. And I think part of that too is when you're thinking about the bare trust, and this is where Kate can be quite useful for it, is still considering them as a shareholder as much as possible. You don't just sort of put investors into a bare trust and consider that they're all separate. You want to consider them pretty much exactly the same, except for there's this little structural break in between that helps with the structure on paper. But otherwise, you still want to consider them as much as you can the same as any other shareholder for it to be successful and to have the ongoing support of your cap table.
Yeah, and we'll discuss it later on. We're talking about shareholders agreement, but it doesn't change. Just by having a bare trust doesn't mean the rights of the shareholders change as well. They're still treated as shareholders. They have the same rights to dividends, voting. It's just that there's this one layer in between, which does that for you a little bit. And we can talk about the power of attorney controls and things like that. But yeah, it doesn't change who the shareholders are. Yeah.
We've got another question here. You may be coming up to it, so feel free if you're going to cover it later. But Mark's just asked on, timing wise, thoughts on retrospectively moving smaller shareholders into a bare trust structure. I know that if you're covering that one off, feel free to park that until you get to that place in the presentation.
Yeah, we will actually talk about that, but it is a good question, is how do you move them in? I'll talk about it in the next few slides. So yeah, Mark, we'll cover that shortly.
Cool.
Yeah, I think for me, it's related to the 50 shareholder limit a lot there. And I think we're seeing it increasingly now that people are getting closer to that limit quicker. It might have something to do with increased angel investing, which I think is a great thing, the increased angel investing ecosystem and more individuals coming in to support startups. But unfortunately, based on the 50 shareholder limit, the downside is that can get you to that limit quicker. So they're then having to think about solutions where if angels haven't come in through a syndicate and they're coming through as individuals, that's where this limit can become a problem a little bit earlier. So yeah, it is often startups are on the back foot a little bit doing it retrospectively rather than proactively, but Helen will be able to speak to the pros of being able to be proactive with it shortly as well.
Just jumping in here about some tax and legal considerations, just to be mindful of. I'm not going to go into them in detail because each one of these are complicated and definitely something that's case by case. From a corporate perspective, something to keep in mind is that when setting up a bare trust, the type of trustee that you put in place is really important, and thinking about the AFSL rules as well. The reason why that's relevant is under the AFSL rules, if a trustee is providing custodial services, which is where the bare trust comes in, because it actually is holding shares, which is considered a financial services asset or interest, that would fall into the custodial services because that trustee is holding those assets on behalf of another entity. You have to consider the AFSL rules. Now, the AFSL rules won't apply if you fall into an exemption, and there are a number of exemptions. I'm not going to go into them today, or there are less than 20 investors that are falling under this particular bare trust. Now, the 20 investor cap applies to associates as well. So a company that sets up multiple bare trusts, each one holding 20 investors, is not a way around it. It's 20 investors for that one company. So it's just important to keep in mind when setting up this type of structure is, are you under that 20 investor rule or are you over? If you're over, do you need to consider the AFSL rules and what can you do to then mitigate it? Something I'm going to touch on more like in the next slide is actually when we're setting up and choosing your trustee, is a way to get around the AFSL, but I'll just leave that to the next slide. The second point I've just noted there for our corporate side is the disclosure requirements. So when you're issuing shares to investors, there are certain disclosure requirements you need to meet under the Corporations Act. There are some reliefs, such as the 2012 rule, where you have 20 investors coming in the 12-month period. If you're not falling into the various exemptions, then you have to provide disclosure to those investors. A lot of startups do actually have to do that because a lot of them are raising more than $2 million in a 12-month period. So these disclosure rules don't actually go away just because you have a bare trust in place. And that's something to keep in mind, is you still need to adhere to those disclosure rules. You still need to get advice from your corporate advisors as to what those obligations are. So yeah, 2 points just keep in mind. From a tax perspective, the key thing I wanted to raise here is actually just making sure the arrangement itself is documented. Charlie raised it earlier, is making sure this trust is actually a bare trust and not actually another type of trust, and that is making sure the agreement that you've put in place is that of a bare trust and those terms are appropriate. It does kind of then impact on the tax implications when you're trying to transfer shares out from the bare trust to the investor, because ordinarily when you're transferring shares from one entity to another, there's a taxing event. It's a CGT event, and CGT may be payable on that transaction unless this is a true and genuine bare trust arrangement, because that trustee is only holding legal title of the shares on behalf of the real beneficial owner, being that investor. So it's important to make sure that this arrangement is documented correctly. And then it kind of flows on to, if it's a true bare trust arrangement, the tax paid on dividends is to the investor, and any capital proceeds on a exit would be paid by the investor and not the trustee of that trust. The last point I've just got there is about ESIC. So some of you may already know about the early stage investor concession that's available to investors that are investing in a company that's a innovative company and meets certain conditions. It's a really good concession, and I think, Charlie, actually you mentioned there's been an increase in angel rounds and a lot of people now hitting that 50 shareholder limit. It may also because the ESIC concession is now, I'm finding that a lot of clients are now more aware of this concession, and maybe a few years ago it wasn't so I guess talked about, and because of that there are people now wanting to invest more into certain types of startups. So I don't know if you have any thoughts around that, but just around that point, if with the ESIC concessions, the shareholder or the investor is the one that receives a concession. We actually had a question around this recently, is does that investor, if they're investing via a bare trust, does that mean they don't actually get the ESIC benefits. I haven't seen this, as a opinion from the ATO, but my view is that because the true owner of the shares is the investor, then that flows through, the asset concessions flow through, just like the CGT implications flows through to the real and true owner being the investor. So I wouldn't think the
Right.
asset concessions are impacted.
Great. Yeah, I think as you're going through this, Helen, it was making me think. I'm a big advocate for templates in the right circumstances, especially for early stage startups and founders. But we sometimes hear founders come to us and say, oh, they've come across an open source Bear Trust template or shared Bear Trust documents. For me, it's certainly not something you'd want to approach with a template because there are so many variables based on how your company is structured, who the investors are, what your cap table looks like currently. And it's not something you want to hack and get wrong. Just like we talked about at the start, it can have pretty painful consequences later on.
Yeah, that's right. And obviously tax is just one consideration, but getting that wrong at a point where you're trying to raise money or exit, it just makes things so difficult, and trying to cleaning up later is yes, just hard and
Absolutely.
embarrassing. Yeah.
Yeah.
So yes, as I mentioned, I was going to just touch on how what is involved in setting up a Bear Trust, and Mark, you mentioned what happens if you've already got minor shareholders, how to move them into a Bear Trust, and that's at point 8 in this slide. So I'll touch on that at the end. But when you're thinking about setting up a Bear Trust at the beginning, you need to think about, okay, what approvals do I need to get, particularly if you've already got a number of shareholders and you have a shareholders agreement, and it's not just at the point where you're setting up the startup itself. Is looking through your corporate governing documents, which is your constitution and also your shareholders agreement, and seeing, can you do this in the first place? Do I need to give notice to my shareholders? In most cases, it's just a pretty straightforward approval process, and it's just going through those requirements in your governing documents. The second point is, whilst you're going through this process, do you need to update your shareholders agreement to, one, allow a Bear Trust arrangement to be in place? Secondly, ensuring that your shareholders agreement deals with the fact that a Bear Trust is now holding the shares and that those rights that your shareholders ordinarily would have is not removed, and that your shareholders are still they still have those rights as a shareholder. So that's actually a change we highly recommend is looked at in your shareholders agreement right at the beginning. And also just making sure if there are any power of attorney clauses, it deals with the Bear Trust as well. And then the third point is deciding on a trustee. So as I mentioned earlier, who your trustees are, it may impact the AFSL rules, and just thinking through that carefully and getting advice on it. We generally recommend the trustee is either a wholly owned subsidiary for AFSL reasons, and also for control reasons as well. The second option on setting up a trustee is a corporate managed trustee, and now that is an AFSL registered trustee that does this as a service. You engage those corporate trustees to provide this AFSL service. They are already registered with an AFSL license, so you don't need to worry about the 20 investor rule. We find that with these managed trustees, they are very expensive. So it's something you would consider if you are definitely hitting that 20 investor rule over, or you can't obtain an AFSL, and it is difficult to get an AFSL. So I'm not an AFSL expert, and it's something that I always defer to our specialists in Legal Vision, because it's just a complex area. If you don't want to deal with those rules, then definitely engage a managed trustee to do that work for you. Once you've decided on a trustee, then it's setting up the documents. So we would prepare a nominee deed where the company itself appoints that trustee to act as nominee for each of the investors coming in. Once that nominee arrangement is set up, the investors then enter into a Bear Trust deed, appointed that nominee to hold those shares on its behalf. So each investor would have their own bare trust deed. I've got here as well, investor signing a power of attorney. Now this is optional. I say it's optional because it's essentially, we're suggesting that the investor signs over the power for that trustee to make certain decisions and sign certain documents on its behalf. It's something that, from a practical perspective, we actually see a lot of pushback because a lot of sophisticated investors don't want that control to be handed over to a trustee to sign and make those decisions for them. It's not a requirement to have this power of attorney, but it does make things easier because it means the director can sign off documents and reduce the administration burden, especially if you've got a number of beneficial holders under a bare trust arrangement. Charlie, did you have any thoughts on the power of attorney point? It's kind of an area that we see a lot of pushback and from the investor side, but from the company side, it's really beneficial to have that power of attorney ability just to sign those documents.
For sure. Yeah, I think for me, it depends on who the investors are and what their expectation was coming into the company as an investor. Were they small, sort of early family and friends rounds that expected just to help out, but weren't necessarily looking to have votes or weren't overly concerned with the corporate direction that the company goes? Or was it more of a considered investment from more of a professional investor or an angel investor where that's important to them?
Yeah.
And I think overlaying all of this, so these are the corporate steps and the paper steps required, is really just the company communication with the investors, because there's obviously so much documentation the investors would need to consider and get signed. And the worst way to do it is for a company just to throw documents at them and say, sign this, because of course then the investor will be on the back foot and try and find reasons why they should not sign it. So the way we see it done best is the communication starts really early. So we see companies using the Cake communications tool, for example, sending out months in advance communications on what they're doing, why they're doing it, why it will benefit the company as a whole, how it will help the company move to the next step and increase the value of their equity, how it won't impact the investors and they'll still be able to log in and see their holdings, how they'll still get all of the updates and they'll still be joining on the journey. Just really over communicating the whole way through, because what that will also do will mean that when you get to the step that you might be requiring 10 to 20 investors to be signing documents, it won't take you 2 to 3 months. And it won't cost you more in legal fees trying to chase people down either. It will make it a lot more streamlined to make it smooth and collaborative rather than a sort of a feel of a forced deal, which never ends well in the first place.
Yeah, no, really good points. The transparency is just key to running a successful or a speedy kind of process and getting your investors on board. I definitely agree. Just on the next point here, I just have from a legal perspective is making sure that you have your register in place for a bare trust. So as some of you already know, when you have a company, you have a share register and you have all your shareholders on that register. On that register, when you have a bare trust, it's just going to have the trustee of that bare trust. So there will need to be a separate register where that trustee holds the shares on behalf of all the various beneficial holders, and that's very clear. This is really good evidence to show that this trustee is only holding these shares as bare trust for all these various beneficial holders, and is not actually owned by that trust.
Yeah, and I think on that point, Helen, on Cake, the way it's managed is that you have that holder being the trustee that's shown as legally holding those shares in terms of the owner. But then you can go one step further to another layer where you can list those beneficial holders and see the percentage ownership and the actual shares that they beneficially hold that way. So on the investor side, it's about transparency. So if they were to go through this bare trust process, it's not that they can't then log in and see what their holding is. They can log in and see the exact same thing, but it represents a beneficial holding rather than a holding that would be shown on ASIC, for example. So, and in terms of the trustee, they're able to then manage that through Cake as well. So they can log in and see, okay, here's all the beneficial holders that hold below. And then for any administration of transfers and sales and whatnot, it's much clearer than having two separate registries out there.
Okay. So when on the Cake system, is it that all the notices and everything can easily be sent out from the trustee side, and it will just be entered in and then just sent out to all the beneficial holders on that register. It's very simple.
Absolutely, yeah. It's just
Yeah.
a matter of clicking which group you'd like included in different communications and different actions. And for the most part, we've got a bunch of companies that use Bear Trust. For the most part, they include Bear Trust beneficial holders in pretty much everything, other than obviously anything requiring a shareholder signature, because that just goes to the trustee, but they'll still send the communications to the beneficial holder so they're in the loop and understand completely what's going on.
Yeah, no, that sounds amazing. I've seen the cake system on the employee share like schemes and how it's so streamlined. So it sounds like it's very similar on the Bear Trust, and it just keeps everything so simple and streamlined, and maintaining that transparency, which is like, we were saying, is quite critical.
Absolutely.
So that sounds really great. So just moving to the point 8 there is what happens if
Hey,
you've already got. Sorry.
Helen and Charlie,
Yeah.
we've got a couple of questions around just the AFSL and like when's it actually. So there's one around, is Bear Trust required to be audited, given they have an AFSL? So I'm not sure whether there's an assumption you need an AFSL for all of the Bear Trusts in that question or not. I'm not 100% sure. And then there's another one about, what is the threshold before you nominate an AFSL? I think you mentioned it briefly, but I just thought I'd throw those in again.
Yeah, so as I mentioned, I don't, I'm not an expert in AFSL. We have a whole team that deals with the AFSL requirements, but on a high level, if you're setting up a Bear Trust, because the trustee itself is holding the shares, as I mentioned, on custodial for the various shareholders, there is a requirement to have an AFSL unless an exemption applies. One of those exemptions is if your investor limit under that Bear Trust arrangement is 20 or less. So if you have 20 investors or beneficial owners under that Bear Trust, then you don't need to obtain an AFSL. If you have 21, then yes, you do. You have a requirement to then obtain a financial license. Going down that path is a long process, and you have to have meet certain requirements. And one of them is that you need a financial manager who meets certain qualifications. And I think from memory, when I was speaking to our AFSL advisor, it's a minimum of 6 months of waiting for that license. You may not have that time. So that's when you look to other alternatives is, can we fall under a different exemption? Can we keep it under the 20 beneficial holders? Or do we need to engage a managed trustee? A managed trustee, one of them is Perpetual. So Perpetual, provides those types of services where you can pay them to act as trustee in a Bear Trust arrangement and hold these shares on behalf of all the investors. It's a quick solution to do that, but it can be a very expensive process as well. And something we've found from a practical side is that some corporate managed trustees don't do all the administrative side. So they don't issue all the notices. They don't, provide all the communications to your beneficial holders. That's back on you and as the company. And that's actually where Cake would come in quite well, because they'll be able to streamline those communication processes for you that your corporate trustee doesn't do. So just something to keep in mind from a practical side and a cost side. So that's a really high level kind of guide, I guess, on the AFSL reasons and issues. Charlie, did you have any comments on that? And do you think that explains
Absolutely,
the question? Yeah.
I think so. I saw another comment come through saying so we should keep Angels syndicated then, and yeah, I think if you can, that's great. If you can have Angels coming through as one entity rather than 10 or 20, that will help keep your cap table cleaner. And again, it doesn't mean you need to sacrifice those individual Angels not feeling involved. You can still manage them through Cake, just not as a shareholder, but as a separate stakeholder, so they can follow the journey.
Yeah.
It not crowd your cap table too early.
Yeah, I have actually seen that where the shareholder itself has an underlying bear trust with a bunch of other investors on their side, but when they're investing, it's just one shareholder, and that comes in as a separate shareholder, so it's not actually flooding, the startup's cap table.
Yeah.
Yeah, so there are certain ways to kind of negotiate or discuss with your investors, and then again, that's coming back to just communicating with your investors right at the beginning. So if you are at that point where you're potentially hitting that 50 and your investors are coming in, maybe they have a separate arrangement together and set up their own bear trust and then come in as one.
For sure.
Yeah. I just wanted to go back to Mark's question because that's the point 8 here, where you do have an existing minority shareholders and how to move them into a bear trust. So if you've got a bear trust that you've set up because you've done 1 to 7, it's now looking at how do we actually move these minority shareholders in. And really, you need to get consent from your shareholders first because you can't force them. You can't force them to go into a bear trust if they don't want to. And like Charlie said, it's really about communicating. How does this work? We have people that are concerned that are we actually now, disposing of our interest, and now we no longer have control over of those interests. What does that mean for us? How does it impact us personally on a estate planning side, asset protection? Does that change anything? And having those conversations. But then again, it's like getting advice on your side as a company to be able to even pass on that kind of information, noting it's information only and not advice. So as startups, we shouldn't be advising your investors. They each need to get their own independent advice. So yes, getting consent from your shareholders if they agree to the transfer of their shares into a bear trust, noting that it benefits them too, having the structure in place. Once they're in, you need to prepare transfer forms, transfer them into the bear trust for the trustee to hold. They'll sign the bear trust deed, appointing the nominee to hold the shares, signing the power of attorney if you need to do that. Obviously entering them into the bear trust registry, cancelling the share certificates that the previous shareholder held, and then issuing new share certificates to the trustee that now holds those shares on behalf of that that shareholder, and then updating ASIC and as well as the bear trust register. So it's a pretty straightforward process, provided your shareholder agrees.
Yeah,
And
I
from a
think
tax
the way we see
perspective
it
as well. Yeah, sorry. So, Charlie, if you don't mind, I just finish that point because Mark's also asked us the tax implication on that shareholder. So, as I mentioned earlier, from a tax perspective, if it's a true bear trust arrangement, then you actually haven't changed the beneficial ownership of those shares. You, as that shareholder that's transferring in, you don't hold legal title, but from a tax perspective, you're holding the beneficial interest and the beneficial title to that those shares, and therefore there's actually no taxing event that occurs. There's a specific rule in the tax legislation that deals with a change in legal title, but not a change in beneficial ownership. So from a tax perspective, it should not result in a tax implication for that shareholder. But as we've mentioned before, it's really important to make sure the structure is, implemented correctly and the documentations are correct and they reflect a true bear trust arrangement.
Yeah, absolutely. I think, as we mentioned before as well, it all comes to the pre-steps of the communication and the investor education too. And I think when I see it done best, it's they'll often provide frequently asked questions to investors with exactly questions like that. Will this affect my tax? Will I have to change? Will I have to tell my accountant? Will I lose control? So covering those questions up front, and even running just a webinar, especially if you're dealing with over 10 investors, having a meeting with all of them where you explain it, maybe you go through a deck explaining why you're doing it and why it benefits the company as a whole. You never want it to be perceived as you're just trying to get more control or you're trying to, shaft people out. You need to explain the benefit to the company in cleaning up the cap table for the ongoing success and perhaps for the next capital raising round, what it could mean for the value as well. So ongoing management, I'll let you start with the first ones, Helen. We've sort of been through a bit of this already.
Yeah, I mean, it's kind of the same thing as actually just you know, obviously having those communications of everyone and making sure you have clear documents as to what everyone's roles are in this arrangement, because I think that's the issues that we see is sometimes is understanding who's doing what, and setting out right from the beginning, whose roles, because it makes a difference as to how you then manage this on an ongoing basis and who's actually signing off documents. Is it the trustee or is it the beneficial holders, and at what point? So I think from our perspective, we set out a guide in our suite of documents that we send out and prepare, so that it's really clear, how do you manage your bare trust, who's doing what, and making sure you're updating your register, um, and when you're signing share transfers, who's signing those. But like what Charlie was saying, it's if you have a system like Cake that kind of administers and manages that for you, it just simplifies that process without having, I guess, the headache where one person in the company is overseeing it all. Um, and it can be quite onerous, especially when you have a number of underlying beneficial holders.
Absolutely, yeah. I think knowing who in your company will take on some of these duties is useful as well. If you're a sole founder and you're planning on trying to take this on yourself in the early stages, just make sure you're ready for what it may involve. If you're later stage, which is more often where we might see some of this, you might have the operations manager, the finance manager, the CFO, or even the legal counsel managing this side of things, which can be a bit easier. And then that way you can ensure everything's actually signed off correctly and you're not chasing your tail when you come to a capital raising round.
But it's also maybe having too many people at the same time as well, and
For
that can
sure.
actually clash. And making sure it's very clear at the beginning who's doing what. Like you mentioned, if you have all those people and everyone's trying to do the one thing,
Yep.
it's understanding, are you putting all your resources into the right box? And from a, I guess, cash flow and financial perspective, are you utilizing your resources appropriately? And do you need to then, outsource that kind of work to
Yeah.
someone else? Yeah.
Absolutely. Cool. And then in terms of managing beneficial holders, we've sort of been through this. It's about starting early. So if you are looking to transfer shareholders across from the standard structure into a bare trust, you definitely don't start with sending them a document. Start with the education piece, frequently asked questions, make sure they understand the benefit. Likewise, if you're looking to allow new investors to come into a bare trust, it will require a bit more conversation up front, and it's not something you want to do just as the deal's about to progress. It's something you'd be talking through with the investors in terms of how they're structuring their investment. And that's a bit more related to where syndicates might invest, for example, like we mentioned, and they might have their own bare trust. Over communicate. So again, we see lots of companies using the Kate comms tool to streamline that and send out months before they set up a bare trust, weekly updates and where they're at with it and what the investors should expect, what documents will be coming, because otherwise it can be very scary for them to suddenly get 3 documents called things like, nominee deed, power of attorney. And the last thing you want is for them to take that to their, traditional accountant and the accountant to tell them never to sign it. It's giving away X, Y, Z without understanding how a startup really works. So make sure you've got the buy-in. And then the obvious one is when you're setting it up, think about it from the investor's perspective as well, for the ongoing management. Think about who the investors are, what the expectation was when they invested, what the relationship was with the company, and make sure that they're treated equally based on what they started as. So while it is good to balance the governance and administration where you can streamline some of that through a bare trust with power of attorneys, if the investors were really wanting more active involvement, just balance that out with making sure you're not taking anything away from them that's important to them to have that continued support. All right, I think we're almost there. We're almost at time, so we're at questions. So I'm not sure, Carl, if there's any more questions that have come through the chat.
I think we're good.
Oh, I did have one. I had 2 that were sent in earlier and asked us to cover, and one of them was, how does ASIC see bare trusts? Are they recognised on ASIC's side? Helen, probably best for you to speak to that one.
Yes. So on ASIC, as some of you may have seen on an ASIC, when you're doing a search or looking at how it's set out, But there's a little box that says, is that entity holding these shares as beneficially owned or non-beneficially? If it's a bare trust, it would say non-beneficially, and that's all it would say. So ASIC doesn't require you to submit the bare trust deed or any of the terms under this arrangement. It just requires you to put down the legal name of the entity that's holding the shares on behalf of the various beneficial owners. So none of that information is provided to ASIC. From their perspective, they don't require it. It's very much like when a discretionary trust is holding shares on a trust, it has the same non-beneficial holding. Obviously, if you go into the AFSL territory, then it's a different, whole different ball game, and that that information will then go through to ASIC. But yeah, that's quite separate.
Amazing. And one more question. I thought we had a slide on this, but maybe I'd skipped it through my butterfingers, and apologies if I have. But alternatives to bare trust, if bare trust isn't the right approach for you.
Yeah. So we I know, Charlie and I have, we've spoken about this is, if you're in a situation where, if you're not wanting to do a bare trust, and there may be certain circumstances why you may not, some of them you might look at as a management investment scheme. They are very different and quite complex. And they also have certain regulations and compliance and tax reasons why you would or wouldn't have them. Crowdfunding is another one, but it's also quite different. I think for me, it's really understanding, what are you actually trying to do? What are you trying to achieve? Do you need a bare trust? And why are you even setting one up? If you don't actually need a bare trust, because let's say you're not hitting the 50 shareholder limit and you don't have any admin reasons, then are you trying to do something different? So maybe it's actually a different type of structure that we need to look into. So my first question is, what are you trying to achieve, and what are your intentions? If you're maybe looking at moving overseas or going into a different jurisdiction, a bare trust is probably not appropriate. Moving overseas and flipping up to a different jurisdiction might seem like a different solution if you're moving into a higher cap table number, because, like, for example, in the US, I think the limit is 500. So obviously it's very different here, 50 and 500, and you may think, okay, well, might as well flip up to the US and take advantage of those numbers. However, doing that just results in so many other kind of considerations, and it's a lot of work to move into a different jurisdiction and flipping up. And it's not the easiest solution, but there could be other reasons why you want to move into, the US, for example. You might have investors in the US looking to only invest into a US entity. But that's a whole different conversation to be having, and a bare trust there would not be appropriate.
Yeah, I agree. Having personally been through exploring the bare trust route and then actually ultimately flipping up to a Delaware C Corp, the one thing I can say is the term flipping up is misleading. It makes it sound very simple, and it's not. So I wouldn't consider that a simple alternative to a bare trust, and definitely that's something I'd only consider if, like you mentioned, Helen, investors are requiring that. Or it's part of your company strategy, and there'll be benefits to that. But otherwise, yeah, don't take flipping up as simple. I can see a couple more questions coming through. We've only got a couple of minutes, so we'll see how much we can get through. Cost of setting up a bare trust is a great one.
Yeah, so the cost of setting up a bare trust is the legal side. So it's from the legal professional fees perspective. It really depends actually on how many investors coming in. So, and also whether you're requiring us to set up the corporate trustee. So if we're just setting up a corporate trustee, it would just be the the ASIC fees to set up the company, which I think is around $600. And then the legal fees in setting up the nominee document, the bare trust document. If we're setting, I actually don't know the exact cost of how much we charge, but if we're just preparing like one set of those documents, it'll be a set fee. If you're wanting like specific AFSL advice, it's a different fee. And then also if you're wanting, us to actually administer and prepare every single one of the bare trust documents and attend to all the signatories is very different cost to someone that just wants us to prepare the template legal documents and they run everything themselves. So it really depends on what your legal needs are. And then there's also, yeah, so that's the kind of the cost involved is really just the legal professional fees in setting up their arrangement.
Yeah, I think, like you mentioned, it depends on the number of stakeholders involved, but generally, I think from what we've seen, I would usually say budget between 5 to 10 for the legal side, if you think that sounds reasonable, Helen.
I think that's probably right. We have
Yeah.
seen more, but that's in cases where we are required to prepare all the bare trust documents for every single one of the investors coming in, and they're sitting at about the 15 mark. And so that's the case, and we're also required to obviously tend to the signatories and manage that process as well as the notices, and that's very different. And that obviously costs more than just preparing the documents. But yes, 5 to 10 is probably the budget that I would aim for as well.
Great. And another quick question, if a company has more than 50 stakeholders and they're now considered public unlisted, can they do a bare trust to get back under the 50 and revert from the public unlisted back to private?
That's a really good question. I don't know the answer to that one. I wouldn't imagine you can, but I mean, look, I'm not sure. I would have to check with our corporate lawyers as to whether you can revert back. There probably is a way to change the status from public to private, and restructuring things. I guess it's also about timing, as like how long you've left it, and then is the ASIC now involved, and do you have to provide certain notices? So I'm not sure,
Cool.
but I can get back to you with an answer to that one.
No worries, that might be a book a call one. And then we'll get one more. Legitimate pushback reasons from current or new investors could put forward and how you'd respond and manage this. Yeah, I think it's fear of the unknown from my side, especially from the unsophisticated investors. If they haven't heard of anything called a bear trust before, understandably, this would seem like they're being shafted. So it's making sure that they understand, firstly, it won't have negative impacts on their tax. It won't change the valuation of their equity. It won't change the fact that they're the legal beneficial holder of that equity. And then ensuring that you're very transparent on what it will change, whether that's the way that they might vote for separate things through a different layer, or the fact that if they downloaded a search from ASIC, they won't see their name there, but it's not because they're not a natural holder. And on that point there, I think that is part of the fear that some of the more old school investors will think, especially the old school angels, will think that their investment is invalid unless they can log into ASIC and see their name there. And you can imagine the fear when they're not there and wondering if the founders just got rid of their equity. So making sure they understand the structure is important.
And I think just on that second part is how would you respond and manage this is probably just having a conversation with them and helping them understand what you're proposing to do. Like Charlie mentioned earlier, is over communicating and making sure they understand why. Why are you doing this in the first place? What does it actually mean? And then all the reasons that Charlie said, it doesn't change their ownership or their rights under the shareholders agreement, and all those kind of things. So yeah, it's just having a clear conversation with them and not just sending like a legal document to them and freaking them out.
That's right. And
Yeah.
one more question, can foreign investors be included in a bear trust?
Yes, they can. So it would just be the same process as well. It doesn't mean that investor now is an Australian tax resident. Again, it's making sure that the terms of that bare trust deed, it would need to just deal with the fact that they're a foreign investor, and there may be certain compliance things that we need to just deal with when doing that. But yeah, from a tax perspective, they would still be treated as a non-resident. And from a legal perspective, yes, you can enter into this arrangement from a foreign investor coming in.
Amazing. Great. We're at time. We will circulate these slides, and these slides do have a discount coupon for both the use of Cake to manage your cap table and manage your bear trust and get your communications out there early if you are considering putting a bear trust in place. But obviously, as we mentioned, Cake is not there for the legal advice. That will be what Legal Vision team will be there to help you with. There's also a code in here to book in with the Legal Vision team. if there were any questions that you weren't able to ask or that come up after the fact, please don't hesitate to email us, book a call. And yeah, we hope this was really helpful.
Thanks, everyone.
Thanks, Charlie. Thanks, Helen. Thanks, everyone, for joining. We'll also shoot through the recording of it as well if you got any, you want to go back and pick up anything from the recording as well. So thanks very much. Appreciate it.
Thanks,
Thanks,
Charlie.
everyone.
Thanks, Carl. Thanks, everyone.
Cheers, everyone. Bye.
See ya.
Bye.
Bye.